certainly is not true.
Thank you for your clarification. Can you walk me through a little bit about the people who weren't hired to replace the group that was let go, but the 3 people who came in the day of the layoff as their first day of employment, it'll be September 1st of 2011, I believe. At what point did you advertise for those positions?
Yeah,
Forgive the interruption. I want particularly the chair's question to be answered, but I think we're going to have extra time. Sorry.
oh no, sir, thank you. The question again, ma'am?
When did you advertise for those 3 positions that would be under your reorganization, that for the 7 who were let go, those 3 that would be coming in for the new style of the way you're doing business? When did you advertise for those positions?
Yes, ma'am. In working with Human Resources, those positions were not merit qualified, so there was not a public advertisement for those positions.
Those you were switching to at-will for those?
Those positions were classified through Human Resources as at-will, correct?
Okay. And what about the interview process? Who was involved in the interview process for those people?
I'm
sorry, you can comment.
Yes, ma'am.
Can I know the next question?
Certainly.
We'll next call on Representative Butler to be followed by Senator Shelton.
Thank you, Mr. Chairman. And thank you for the clarity. I want to focus on your confidential agreements, the settlement agreements, if you will. Can you run me through how you know, or how you were notified of how much to pay a person for signing these confidential agreements? And then how did you pay them? And is there bills and receipts? Follow me through the money.
Representative Butler, there were the agreements were determined through a risk analysis for those employees. They had appealed their grievances to PERB for a hearing. At that point, PERB always requests or asks if the parties would be willing to go to mediation. It's our policy, our department's policy, to always agree to mediation. That's an attempt to try to settle things before going through a hearing. If an employee requests that, we'll do it. If PERB requests that, we will go to mediation. So those agreements were crafted, the agreements we're talking about were crafted by a PERB mediator. The amount of payments, we had done an analysis ahead of time and had what we call a walkaway number for each employee. That was based on an analysis of what our risk would be if we actually went to a hearing and lost every hearing, which you never know. So that was our risk analysis. The risk of that happening was $4.3 million. We then looked at each employee individually. We had a spreadsheet that said each individual, and we came up with an amount that we would not go over to settle these grievances. So we had a walkaway number. We never reached any of those walkaway numbers. And again, one of the reasons we had the confidentiality clauses was to keep us within those walkaway numbers if possible. So once those settlement agreements were signed, we then had a legal requirement to pay those employees the amounts on the face of the settlement agreement. As I mentioned in my opening statement, none of them qualified to go to the appeals board because they weren't back wages from a prior fiscal year, and we had money within our operating budget to satisfy those claims. So those claims were paid out of the operating areas where those individuals were laid off. And that's all traceable through the accounting system. You can tell exactly what organizational areas those monies were paid out of, and that's where they came from. So it wasn't like we had extra money, we had to go find money, we shifted money around. It's all very, if you want to go through the accounting records, it's all very clear and apparent what was done, why, and where those monies came from. The reason we had money in our operational budget to cover that was because we had $730,000 worth of a year of operational savings because of those strategic changes we had made. So we couldn't go to the appeals board and ask for additional money. We had enough money to satisfy this fund. Did that answer your question?
Pretty close. How much is in this walkaway account now?
Look, there's no account. There's no account. It was simply an analysis we did so that in our minds, as we negotiated with each individual, we had a number that we knew we would not go beyond.
Okay, this walkaway number was set up by individuals around the table or a computer or?
It was done in an analysis by our labor relations team, an analysis of where their income was, what would happen if we lost the hearing and that sort of thing.
Who's on the team?
I believe, I don't know. It was presented to me after it was done, so I can't say specifically who was on there. I could probably find out.
Anyone from the Attorney General's office?
No.
Okay.
No, it all would have been internal to that.
Okay.
Yes.
Second question is, in your opinion, you reference these confidential settlement agreements, and I've read some of them. After they've been broken, is there any way that you or the AG's office will go after the dollars that were paid for the confidentiality?
Well,
Because obviously, they've been broken.
Representative, the confusion, and this is why we strongly encourage this body to change the law. The confusion is with the Attorney General's office as well as a lot of other entities within the state as to how enforceable those clauses actually are. At the time these settlements were agreed to, the opinion of the Attorney General was that they were enforceable. Shortly after these agreements were signed, the Attorney General came out with a memo through Assistant Attorney General Julie Potter, and there had been some, it was either a court case or an arbitration, there was some precedent that had been set that they felt they were not enforceable. So the question was kind of put to rest, but at the time there was some question as to whether these clauses were actually enforceable. Not if they were lawful, there was nothing wrong with them with regard, they were lawful, but there was a question as to how enforceable they were. So I would be careful to say that we should hold anybody to those clauses. That would take someone with a much better legal background in mind than me.
Who would that be?
Probably the Attorney General's office.
Because we're talking close to, $730,000 that we know of at this time? Would that
Not
be
with
it?
these agreements, and the total number, I know that's been out there, but I'm not really sure what that is.
Okay, so,
We're out of time.
okay, thank you.
Excuse me, real quick, Father. Chair next call upon Senator St. John, be followed by Representative Scott.
Thank you, Mr. Chair. Question for Mr. Carroll. I want to just continue on Senator Peterson's question for a moment before I do that. Who signed off on the reorganizational plan before you started the implementation?
I did.
No one else above you?
Well,
You just-
other than the procedure I mentioned before, where it's signed off, the reduction in force plan.
No, the whole reorganization.
Well, that's, the result of that was the reduction in force plan.
Okay.
Yeah.
So that was entirely your duty.
The structural reorganization and the idea of how to improve the organization was me and my team's idea. The approval of that, the approval of the reduction in force went through the process that I told you before, which started with Human Resources, came to my desk, I signed off on it, went to Department of Management, they signed off on it, and then went to the Chief of Staff, and they signed off on it. So that was their involvement in the restructure.
I understand, and that was after the fact, though, that the decision has been made,
Right.
and then everybody signs off on that, and at that very top level, that was you.
That was me.
Okay, let's go to the interview process then. So we were told yesterday that there were people waiting to take the jobs of the folks that were laid off. How did you go about selecting these folks? What was their background? I mean, these were engineers and folks that you said you had very trouble. I mean, they were long-term state employees, laid off, and disrupted lives. Now, what were the qualifications of the people that you brought in, and who were these folks?
Actually, I wasn't involved in the hiring process, so I can't answer those specifically. I do know that the ability to communicate between the departments and our construction managers was very, very high on the list of qualifications that was necessary, which would have required them to have some knowledge of construction and contracts and that sort of thing. Outside of that, I didn't see any of the resumes. I wasn't involved in the hiring process, and I don't really know why specific individuals were chosen.
Who did that?
I did that, sir.
Well, I'll direct it to you.
Absolutely, yes. Good afternoon.
Please.
Yeah, the interview process took place before the layoff, as we were strategizing for the layoff for business purposes. We understood that it was very important for us to have a seamless transition from the previous methodology and delivery of our construction projects around the state to the direction we were going. At the time, there was about $430 million worth of construction projects happening in our state. That, in our region or in our state, let alone nationally, is a tremendously large dynamic portfolio. There was, in that $425 million, $403 million worth of projects, there were approximately 125 projects on the books. So it was a very, very dynamic time, and it was important for us in leading that process and representing taxpayers on those projects. It was important to have a seamless transition. We were very concerned that we could not have a seamless transition if we didn't have a group of individuals, a small group of individuals, prepared to work within the new established business philosophy of representing the projects the way that we currently do.
Do you have the names of these individuals?
The individuals that were hired?
Yeah.
Yes, certainly. Calvin Miller was one of them. Brant Carr was the other. And Evan Kagan was the third.
And what was their position then as they were hired?
All three of those had engineering and construction backgrounds and education and experience. Two worked for contractors, construction contractors, and one was a public service employee.
And what was their new title then that they were given?
Originally the classification was an EO3 title when they began their duties as assigned by Human Resources.
And that's like a bureau chief?
It was believed to be a bureau chief at first. We later learned from Human Resources that it was more appropriately classified as a senior resource manager, and that better fit in with their job descriptions as personally representing agencies rather than representing construction projects. So that determination changed to senior resource manager at the advice of Human Resources.
So they did not have actually people underneath them, they were just brought in to supervise all these projects?
They were individual contributors as opposed to being supervisors, yes, sir.
And at what salary then as a bureau chief?
I'm not certain of the exact salary. I know that it was about the top of the range, which was in the $90,000 range.
Would that have been higher than the people that they replaced?
It could have been higher than some of those individuals. I'm not certain. I know that to have anyone come in not in the median hiring range, a process takes place through Human Resources to observe what their qualifications and experiences are, and then that determination is set. And that's how that process was followed.
Thank you very much. And I guess I would just close that we lost a lot of institutional knowledge, so I would hope that those folks would be right on the ball when they stepped in with $450 million worth of projects hanging in the works.
Absolutely. We felt the exact same way, sir, and I was taken into full consideration during the process, without question. Thank you.
Chair, next call on Representative County, and then Senator Griner.
Thank you, Mr. Chair. Thanks for being here, Director Carroll. So to be clear, you believe no one broke the law?
I absolutely believe no one broke the law.
But we do agree that this is a practice that should be fixed by law.
Absolutely.
So I'm going to follow up with
This and much more, by the way.
So a couple of comments. Senator Garrett had a very wise statement. We have the executive order, but what are we going to do going forward? And I know you weren't here last night regarding House Study Bill 684, but it didn't pass, and it passed at very late after 11 o'clock at night. how would Iowa be served better by your interpretation of that law?
Well,
In the past and going forward.
I have to tell you, the governor's executive order takes care of one piece of the confidentiality problem we have within the state. That piece, of course, is the confidentiality and non-disclosure clauses that says people cannot talk about the terms and conditions of the agreement itself. What it doesn't take care of is the confidential information that is included on those settlement agreements having to do with why the grievance was filed in the first place and what the situation is around that particular employee. So when you go online and look at what's posted publicly, you'll see a lot of black lines on those settlement agreements that are redacted by the Attorney General's office because that's considered confidential information. A lot of that information has to do with performance issues. A lot of those performance issues can be, I think, a lot of you would find quite shocking. At that point, if individuals are terminated or agree to leave state employment, it's very difficult for anyone else to tell why they left or whether they should or should not be rehired to a position because of it. Frankly, I don't think that's a good practice at all. I think it's, could be dangerous in some cases based on some of the things I've seen. And I would encourage very, very strongly that we make settlement agreements with the exception of very personal information like social security numbers, home addresses, telephone numbers, that sort of thing. Of course, I don't think that should be made public. But the reasons and the instances that occur because of those settlement agreements and terminations, I believe 100% should be made public.
So even with the governor's executive order, there will still be a lack of transparency to this unless something were to be done by the legislature.
Yes, Representative, that's evidenced by, please go online and look at those settlement agreements. It's evidenced by the amount of black on those agreements.
Yeah, thank you. I saw some posts, I'm not sure if they're from the governor or from you. Do settlement agreements occur in the private sector?
Yes.
So how would you compare what has gone on in the public sector in our state compared with your experience in the private sector? And do you think they're good in the private sector? Did they serve the state well?
Good is in the eye of the beholder, Representative. They are definitely a very useful tool, and they're used by both parties typically as a tool to get to agreement. I know that the innuendo and the accusation is that it was to keep things secret. Well, it didn't keep much secret because all it took was a FOIA request to get those agreements. What it did do, it was used as a tool to get to agreement. And it was a tool that the PERB mediator saw no problem with. The problem and the mistake I made was it does not comply with open, transparent government, or at least the appearance of open, transparent government. That was my mistake. I should have realized that. I should have not let them be included.
One final question. Senator McCoy brought up the Attorney General and their involvement. You obviously have counsel that you've spoken of. I just want to expand a little bit in terms of the Attorney General's involvement with your counsel and with you and how this transpired in your own experience.
Well, I have legal counsel within the department. Anytime we're putting an agreement like this together and there are issues that we have questions on with regard to either legality or state practice, state law, administrative rules, things that way, oftentimes we'll consult with the Attorney General's office. Particularly on human resource issues, we have one specific individual down there that we talk to quite often on those sorts of things, and we'll get their advice. And like I said, the advice on these particular types of clauses at the time we included them was that they were perfectly legal. There was some question as to how enforceable they were. That question was cleared up. I believe it was like March 20th of 2013. These settlement agreements were all settled prior to that date, and it was cleared up through some precedent-setting legal proceedings, and I don't remember exactly what it was, but Julie Potter then, if you